Divorce for business owners in Chicago, Illinois. If you own a company and are facing divorce in Chicago, your first concern is likely whether a court can force you to sell or surrender part of your business to your spouse. Illinois law does not automatically require either outcome, but the timing of when your business was started determines how it will be classified in your divorce proceedings. Under Illinois statute 750 ILCS 5/503b, any business started during the marriage is presumptively marital property, meaning it becomes part of the equitable division analysis. However, this classification does not mean your spouse automatically receives ownership or that the business must be sold to satisfy the divorce settlement. If you started your business before the marriage, the original pre-marital value generally remains non-marital property under Illinois law. Even if your business appreciated significantly during the marriage, current Illinois law protects that appreciation as non-marital property when it stems from the owner's personal effort. The marital estate may still pursue a reimbursement claim if marital funds or substantial personal effort contributed to the business's growth without reasonable compensation. Your spouse's lack of involvement in daily business operations does not automatically protect the business from being considered marital property. Illinois courts focus primarily on when and how the business interest was acquired, not whether both spouses actively participated in running the company. Business valuation becomes the most contested issue in divorce cases involving business owners, as the methodology chosen can swing results by hundreds of thousands of dollars. Under Illinois statute 750 ILCS 5/503k, courts apply a fair market value standard, defined as the price a willing buyer would pay a willing seller under normal market conditions. The three primary valuation approaches include the income method, which capitalizes future earnings, the market approach, which compares recent sales of similar businesses, and the asset approach, which values tangible assets minus liabilities. For owner-operated businesses, the income approach is most frequently used because it reflects the company's earning power and accounts for disguised income through draws, distributions, and company perks. Goodwill often represents the largest and most contested component of business valuation, with Illinois courts distinguishing between enterprise goodwill and personal goodwill. Enterprise goodwill attaches to the business itself through brand recognition, customer relationships, and operating systems that would continue generating revenue even if the owner departed. Personal goodwill, however, is tied to the individual owner's reputation and skills and cannot be transferred to a buyer, making it protected from property division. Each spouse typically retains their own valuation expert, and these professionals often produce significantly different valuations based on their chosen methodology and underlying assumptions. Courts evaluate expert credibility, consistency between valuation methods and tax returns, and the quality of financial records when determining which valuation to accept. Call Caesar and Bender, LLP at 312-236-1500, located at 150 N, Michigan Avenue number 2130, Chicago, Illinois 60601 to speak with an attorney about protecting your business in divorce proceedings.